Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Lecture 2 of Conquer Prelims, and in this lecture we will discuss lots and lots of MCQs and the concepts surrounding those MCQs which can be relevant for the upcoming prelims examination. And before we start, the announcement that I will repeat again, a massive reduction in the course fee for 15 months of Unacademy Plus subscription. The course fee, which used to be somewhere around 75,000, has now been reduced for a limited period to under 25,000. This reduction of the course fee is valid for the next few days, I think till May 6th. Please avail this opportunity because the course fee is never going to be the same ever again for at least this year. And should you wish to enroll in this program, on May 7, we are launching another batch, and these are the teachers who shall be teaching you live. And apart from live classes, you will get unlimited recordings of these live classes, mentorship, study material, test series, weekly tests, and also an access to our current affairs program called UCAN, Unacademy's Current Affairs Navigator. Let's get started. There's a question on your screen. You have 1 minute to answer this question, and then we will have an elaborate discussion on this particular question. Question number 1. The Supreme Court cannot take an action against anyone in a criminal contempt matter without the written consent of the Attorney General or the Solicitor General of India. A case of criminal contempt shall be heard and determined by a bench of not less than 2 judges. 3. No court shall initiate any proceedings of contempt after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Which of these statements is or are correct? You have 1 minute to answer this question. The annotated PPT has been made available. You can go through the link of the previous class, and in the video description you will find the PDF of yesterday's class. Let me know what is the right answer. Okay. The correct answer is B. Only 2 statements are correct. But now, let me elaborate. We have a fundamental right under Article 19(1)(a) of the Constitution, which deals with freedom of speech and expression. This fundamental right is exclusively available to the citizens of India. Which are the other fundamental rights which are exclusively available to the citizens of India? Fundamental rights like Article 15, 16, 19, 29 and 30. These are the 5 fundamental rights which are exclusively available to the citizens of India, not available to aliens, not available to foreigners. But if we have freedom of speech and expression, it is not an absolute fundamental right, because there are reasonable restrictions under Article 19, Clause 2 of the Constitution. And how many reasonable restrictions do we have? There are 8 reasonable restrictions, and on these 8 grounds, your freedom of speech and expression can be restricted. For example, sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality or decency, defamation, incitement to an offense, and the last reasonable restriction is contempt of court. But the Constitution does not define what is this contempt of court. The year was 1971 when Contempt of Court Act was passed by the Parliament. And it is this Contempt of Courts Act 1971 which categorizes contempt into two categories. One is the civil contempt, the other is the criminal contempt. Why this topic is important? Because you are aware of what is happening in the Supreme Court regarding the Patanjali case involving Mr. Acharya and Baba Ramdev. Civil contempt means what? Willful disobedience of a court order. If the court has ordered something and you are deliberately, willfully disobeying the court order, that is civil contempt. What is criminal contempt? If you interfere with the judgment of the court, if you scandalize the court, if you cast aspersions on the judges, that these judges have given this verdict because these judges have been paid, or these judges are from particular religion or particular caste, or these judges are biased, which will lower the dignity of the court, and ultimately people will stop trusting the judiciary. That is why the courts have the power to punish people for contempt, whether it is civil contempt or criminal contempt. And which are these courts which have the power to punish people for contempt? Supreme Court and High Courts. These two set of courts, they have the power to punish people for contempt. But does that mean that you can commit contempt of a district court? No. But district court itself cannot punish for its own contempt. The High Court concerned will punish somebody who has committed contempt of the district court. So long story short, High Courts and the Supreme Court has the power to punish people for contempt, whether it is civil contempt or it's a criminal contempt. Clear? That's number one. Number two, can you commit contempt of the district court? No. But High Court will punish you for committing contempt of the district court. District court itself does not have the power to punish people for committing contempt of the district court. But what are the ways in which this criminal contempt case can be filed, for example, in the Supreme Court? There are three ways. One is under Section 15, for example. The other is under Section 14, for example. For example, the hearing is going on. Listen to me carefully. This is an important statement. The court is hearing a matter. And while hearing a matter, somebody is committing contempt of the court, scandalizing the court, interfering with the court. What the court can do, it can order that this particular individual who has committed contempt of court, this particular individual should be kept in custody till the end of the day. That is one way in which courts can punish you for committing contempt. There is another way. And what is that another way? Either the court can act suo motu. That means on its own. Somebody has written something which is derogatory to the court, which scandalizes the court will take this matter on its own. Without somebody approaching the court will punish that individual for contempt. That's number one. Second way is, if the Attorney General for India or if the Solicitor General of India will approach the Supreme Court saying this particular individual has committed contempt, please punish this individual. So one is the court acting on its own, suo motu. Second, if Attorney General approaches. Or third is any other person. Any other person means apart from court acting on its own and apart from Attorney General or the Solicitor General approaching the Supreme Court, any other person can approach the court saying this person has committed contempt of court. But this petition cannot be accepted by the Supreme Court without the consent, without the written consent of the Attorney General or the Solicitor General. But sir, why is this a provision? This can be another statement that can be asked in the examination. The primary intention to have the written consent of the Attorney General before the court can take up this criminal contempt matter is to save the time of the court. Because the court's time is precious. Which means there are three ways in which you can approach the court and file this criminal contempt petition. One is if the court is acting on its own. Second, if the Attorney General is approaching the court. Third, if a third person approaches the court, but you cannot approach the court without the written consent of the Attorney General or the Solicitor General. This is to help the court save its time. So what is the statement? The Supreme Court cannot take an action against anyone in a criminal contempt matter without the written consent of the Attorney General or the Solicitor General. This is incorrect. Why? Because the court can take action in a criminal contempt matter on its own. Suo motu. Not just that, when the hearing is going on, the court can punish an individual saying you are to be kept in custody till the end of the day because you have committed contempt. Because there are other ways also, apart from getting the written consent of the attorney or the Solicitor General. That is what makes statement 1 incorrect. Statement number 2, a case of criminal contempt shall be heard and determined by a bench of not less than 2 judges. This statement is correct because this is mentioned not in the Constitution, this is mentioned in the Contempt of Courts Act 1971. No court shall initiate any proceedings of contempt after the expiry of 1 year from the date on which this contempt is alleged to have been committed. This statement is also correct. That means it should have happened in the past 1 year. Otherwise, you cannot punish somebody for contempt. And what is the punishment for those who are convicted for contempt? The punishment is 6 months in jail or fine or both. And we have witnessed previously when noted Supreme Court lawyer Prashant Bhushan was convicted for criminal contempt of court and he was imposed a fine of ₹1. Clear? So question number 1, what is the right answer? B, 2 statements are correct. Any questions? Okay, let's look at question number 2. Which of the following pair or pairs is or are correctly matched? On one side you have the case name, on the other side you have the matter. Options: only one pair is correctly matched, 2 pairs, all the 3 pairs, none. What is the right answer? Supriyo versus Union of India, Nabam Rebia, Subhash Desai, Dr. J.R. Thakur versus Union of India. What is the right answer? $30 to go. What is the right answer? Most of the students are saying B. But this is not democracy where the majority is right. Okay. C is the right answer. All the pairs are correctly matched. How? Supriyo versus Union of India, it deals with right to marry for sexual minorities. There was a case, and in fact this question was once asked after this case in the prelims examination as well, saying a right to marry is a, and then there were options. So the correct answer then was a right to marry is a fundamental right under Article 21 of the Constitution. Because at that time, the Shafin Jahan judgment was given by the Supreme Court. So there were multiple judgments which Supreme Court said right to marry a person of one's choice is a fundamental right under Article 21. Because it is an integral facet of the right to liberty which is guaranteed by Article 21 of the Constitution. Then the question before the court was, if right to marry is a fundamental right, then shouldn't this right to marry also apply to LGBTQ community? sexual minorities, lesbians, gays, transgenders, bisexuals, queers, intersex, asexual, so on and so forth. And that was the case, Suprio versus Union of India. Because in Navte Johar judgment, the Supreme Court had decriminalized homosexuality. Section 377 of Indian Penal Code was read down. It was not declared unconstitutional, it was read down. Read down in the sense, insofar as Section 377 of Indian Penal Code is used to criminalize adult consensual sexual activity, that is not a crime. But Section 377 can still be invoked in case of unnatural offences. And which are these unnatural offences? For example, bestiality, sex with animals, incest, incestuous relationship. That means Section 377 of IPC was not declared unconstitutional, it was read down, saying only insofar as it is used to criminalize the consensual adult sexual activity, it is not a crime. And the logical conclusion then should have been, if the Supreme Court in Navte Johar judgment recognized right to love as a fundamental right, then right to marry should also be the next logical conclusion of the court. But the Supreme Court said in Suprio versus Union of India that right to marry as a fundamental right does not exist. So right to marry now is not a fundamental right. There are students who often say, sir, right to marry is not a fundamental right, but right to marry a person of one's choice is a fundamental right. But both these are contradictory. If right to marry is a fundamental right, is not a fundamental right, then right to marry a person of one's choice, how is that a fundamental right? Because a gay person, his choice is to marry another gay person, but they don't have this fundamental right. So right to marry a person of one's choice is not a fundamental right according to Suprio versus Union of India. So this pair is correctly matched. Nabam Rebia was related to what? This was in the news because of the series of defections we saw in Maharashtra and Madhya Pradesh previously and many other states. Now in this case, what happens? In 2016, the Supreme Court had given a verdict in a case known as Nabam Rebia. And what was that judgment? Under the 10th schedule of the Constitution, who has the power to disqualify a legislator who has defected, who has violated anti-defection law? That power is with the Speaker. Now, can Speaker disqualify a legislator under anti-defection law? Yes. But what if the legislators have moved a motion to remove a Speaker? What will happen in this case? Can Speaker still act on these disqualification petitions and proceed under anti-defection law? For example, there are 10 MLAs who have defected to another political party and I am the Speaker. What I have to do? I have to disqualify them. But they are incapacitating me. How? They introduce a motion seeking my removal. In Nabam Rebia, the court said, if a Speaker against whom a motion for his removal is pending, this Speaker cannot take any decision on anti-defection law petitions. And now in Maharashtra case and in various other cases, the question before the court was, this is like a ploy by a defector. If I want to defect, but at the same time I don't want Speaker to take an action against me, I will stop him from taking an action. How? By introducing a motion seeking his removal. It raises an important issue. That is why this Nabam Rebia judgment has been sent to a review, and now a 7-judge bench of the Supreme Court is going to review this judgment. So Nabam Rebia is related to Speaker's role under the 10th schedule of the Constitution. Third, Subhash Desai. Yes, this is a case which is related to Maharashtra political crisis, where some MLAs of Uddhav Thackeray's party Shiv Sena defected to the Shinde camp. And what Uddhav Thackeray did, he resigned as the chief minister because the governor had asked him, prove your majority on the floor of the Legislative Assembly, because I think you have lost your majority in the Legislative Assembly. The Supreme Court in this case said that the governor was wrong in ordering a floor test because there was no material on the basis of which the governor should have presumed or assumed that the chief minister has lost his confidence. But we cannot do anything now. Why? Because Uddhav Thackeray resigned. If he would not have resigned, we may have considered reinstating him as the chief minister. But since he resigned and that resignation was voluntary, we can't do much. So Subhash Desai case is related to that political crisis. And the fourth one is Dr. Jaya Thakur versus Union of India. The term of the director of the Enforcement Directorate was extended, and then the petition was filed in the court that further extension should not be allowed. And we will discuss ED and Prevention of Money Laundering Act tomorrow in great detail along with FCRA. So this Jaya Thakur judgment was related to extension of term of the ED director. So all the pairs are correct. C is the right answer. Clear? Any questions as of now? Okay. Let's look at question number 3. Which of the following recognizes the right to marry as a human right? Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, Article 21 of the Indian Constitution. Select the correct option from below. Let me know what is the right answer. So, sir, finally, right to marry is not a fundamental right? It is not. "30 seconds more. Let me know what is the right answer." Don't overthink. How can it be all three? Because it's not a right recognized by the Constitution. Under Article 21, we discussed that a few seconds ago. But Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, they do recognize right to marry as an inalienable human right. So B, only 2 is the right answer. Okay. Let's look at question number 4 and read this carefully. According to the Constitution, the post of Deputy Speaker of the Lok Sabha can remain vacant. In absence of a Deputy Speaker, the Speaker submits his resignation to the President of India. The convention that a Deputy Speaker should be a member of the opposition has been in place since 1956. Which of these statements are correct? Let me know what is the right answer. Sir, you talked about human right, not fundamental right. But when I say right under Article 21, which means I'm talking about fundamental right. So that is not recognized by Article 21. Question number 4, what is the right answer? Can we have the poll, please, on the screen? Question number 4, A, only one statement. A is the right answer. Only one statement is correct. How? Let me explain. Constitution says let's talk about Lok Sabha. And why? Because the Lok Sabha, whose term is ending right now from 2019 to 2024, in the history of independent India, this is for the first time when we did not have a deputy speaker. That makes this topic very, very important for the upcoming prelims examination. Constitution says that Lok Sabha, and please focus on this term, shall, as soon as may be, elect two of its members, one as the speaker, the other as the deputy speaker. So this term shall makes it mandatory that we need to have deputy speaker, we need to have a speaker as well. There is a convention that speaker is the member of the ruling party or the ruling coalition, and the deputy speaker should be the member of the opposition. But this is something which is not mentioned in the constitution. This is a parliamentary convention that we have been following since 1956, when the then Prime Minister Pandit Nehru nominated Sardar Hukum Singh, who was then from Shiromani Akali Dal, SED, and nominated him that you should contest election to the post of the deputy speaker. And then he was elected as the deputy speaker. But it is another matter that Shri Sardar Hukum Singh later on joined the Congress and then contested election from Bathinda constituency in Punjab on a Congress ticket. But that's another matter. But this convention that the speaker should be from the ruling party or coalition and the deputy speaker should be from the opposition, this convention started in 1956. But the constitution is clear that Lok Sabha shall elect as soon as may be, which means the time has not been prescribed. As soon as may be shall elect one person as the speaker, one member as the speaker, the other as deputy speaker, which means both these offices, speaker and deputy speaker, they have to be the member of the Lok Sabha. And how are they elected? They are elected by simple majority. Whoever gets the simple majority gets elected as the speaker or the deputy speaker. But now listen to me carefully. Normally in the first session of the Lok Sabha, the election of the speaker takes place. And normally in the second session of the Lok Sabha, we have the election to the office of the deputy speaker. But for the first time in the history of independent India, we did not have a deputy speaker from 2019 to 2024 in the 17th Lok Sabha. Why? I don't have an answer to this question. In fact, the matter did reach Delhi High Court. Not just at the Lok Sabha level, there were states such as Jharkhand, Rajasthan, where we did not have a deputy speaker. But now the question that you should be asking is, can the courts interfere in this matter? Because there is something called separation of powers. And separation of powers in such a manner that the courts are prohibited from inquiring into, from getting into the procedure of the legislature. So it is like a procedure of the legislature, whether we will have a deputy speaker or we won't have a deputy speaker. So what have courts got to do with this? But the fact is, if the constitution is violated, because the constitution seems to be clear that the House of Lok Sabha, the House of the People, shall elect two of its members as soon as may be, one as the speaker, the other as the deputy speaker. So this has to be a constitutional requirement. So if constitution is violated, the courts are free to interfere in this matter. But we don't have a judgment on this, so we can't comment. The speaker can resign by submitting his resignation to the deputy speaker. And the deputy speaker resigns by submitting resignation to the speaker. So speaker and the deputy speaker, they can resign by submitting resignation to each other. In the Constituent Assembly, when the Constitution was being drafted and debated, there was a suggestion by some members of the Constituent Assembly that why should the speaker submit resignation to the deputy speaker, because deputy speaker seems to be subordinate to the speaker. Normally, we send our resignation to a higher authority. So the proposal was that Speaker should submit his resignation to the President and not to the Deputy Speaker. But Dr. Ambedkar disagreed. Dr. Ambedkar said, we submit our resignation to the one which appointed us. So tomorrow you will become an IAS officer or an IPS officer or an Indian Forest Service officer. You are appointed by the President. So if you have to resign, you will submit your resignation to the President. That means you have to submit your resignation to the authority which has appointed you. Dr. Ambedkar said, Speaker and the Deputy Speaker, they are appointed by the House. So they have to submit their resignation to the House. And who is the representative of the House? Who is like the class monitor of the House? It's the Speaker and the Deputy Speaker. So the Speaker has to submit his resignation to the Deputy Speaker, but what if there is no Deputy Speaker? How is the Speaker going to resign? In this case, the Speaker will resign by submitting his resignation to the Secretary General of Lok Sabha. And the Secretary General of Lok Sabha will then inform the House. And now this information that the Speaker has resigned will also be mentioned in the bulletin, in the Gazette. That is why, according to the Constitution, the post of the Speaker can remain vacant. This is incorrect. If this phrase was not given according to the Constitution, and the statement was the post of the Deputy Speaker can remain vacant, it has remained vacant. But according to Constitution, the very use of the term shall makes it mandatory that Constitution envisages that there has to be someone occupying the post of the Deputy Speaker. Clear? In absence of Deputy Speaker, the Speaker submits his resignation to the President of India. We have discussed, not to the President, but to the Secretary General of Lok Sabha, who then informs the House. The convention that a Deputy Speaker should be a member of the opposition has been in place since 1956. This statement is correct. So which of the above statements is or are correct? A, only one statement. That's the right answer. Clear? Okay. Let's look at question number 5. Consider the following statements. While the Ethics Committee can only investigate misconduct by parliamentary members, the Privileges Committee is vested with the authority to recommend penalizing non-members as well. The Committee on Privileges of the 11th Lok Sabha recommended merging the two committees to create a Committee on Ethics and Privileges. The debate on the report of the Privileged Committee shall not exceed half an hour in duration. Which of the above statements is or are correct? Let me know what is the right answer. And by now you would have realized that this topic is in the news and can be relevant for your upcoming examination because of the Mahua Moitra case. And Mahua Moitra, she was expelled from Lok Sabha on the recommendations of the report by the Ethics Committee. Let me know what is the right answer. 58% students are saying B. Speaker decides the date of the election of the Deputy Speaker. Yes, that is correct. But that is not something which is mentioned in the Constitution. That is mentioned in the rules of business and procedure of Lok Sabha. The date of the election of the Deputy Speaker is fixed by the Speaker. Shiv Kumar is saying B. It's so easy. That is why I will say it is C. All the three statements are correct. Okay? Now let's look at and understand this topic in detail. On one side, we have the Ethics Committee. On the other side, we have the Privileges Committee. Now, as members of the Parliament, they have certain privileges. Privileges such as freedom of speech. No matter what you say, and freedom to vote, no matter how you vote, you cannot be prosecuted, convicted in any court of law. That is the absolute freedom of speech that is available to parliamentarians in the House, in the legislature. But if somebody violates these privileges, that is what we call breach of privilege. And that breach of privilege is then investigated by the Privileges Committee of the Parliament, of the Lok Sabha. And ultimately, if it is by the member of the Lok Sabha, by the Privileges Committee of the Lok Sabha, if it is the member of the Rajya Sabha, by the Privileges Committee of the Rajya Sabha, and then the report of the Privileges Committee is presented to the Lok Sabha, and then the Lok Sabha, through voting, through majority, will decide whether we will act on this report or not. Privilege previously was that you can also vote by taking a bribe. And this is something related to the JMM bribery case, which all of you are aware. I hope you are. And it is this judgment which was given in 1998, known as PV Narasimha Rao versus CBI, Central Bureau of Investigation, that the court said the privilege is the freedom of speech and expression that you have inside the Lok Sabha, which means if you have taken bribe to say something in the Parliament, you cannot be prosecuted. Even bribe is allowed. It was this JMM bribery judgment or this PV Narasimha Rao judgment which was overturned in 2024 in a case known as Sita Soren versus Union of India. She also allegedly took bribe to vote in favor of a candidate in the Rajya Sabha election. But she took the bribe but did not vote for him. And ultimately she claimed that this is her privilege because I cannot be prosecuted in any court of law, no matter what I say inside the Parliament or how I vote inside the Parliament. But the court, a 7-judge bench of the Supreme Court, a 7-judge bench of the Supreme Court in Sita Soren versus Union of India said, you have no immunity as a legislator if you are taking bribe, whether this bribe is for asking questions or whether this bribe is for voting in a particular manner. You do not enjoy immunity. Long story short, there are some privileges which are available. And if anybody, whether it is me who is a non-member or it is you who is a member of the House, if we violate these privileges, it is known as breach of privilege, and that is inquired into by this Privileges Committee. There is another committee called Ethics Committee, which looks into the grounds of or charges of misconduct. Now, what is this misconduct? If a legislator is doing something which is unbecoming of a legislator, if your behavior is such which is not good, for example, somebody is watching porn in the Parliament, or somebody is doing something which does not befit a legislator, so you are doing something which is what we call unparliamentary, that is what we call misconduct. And for that misconduct, there is Ethics Committee of the Parliament. But this Privileges Committee, it can recommend penalty not only for those who are the legislators, but non-legislators as well. Clear? But in Mahua Moitra's case, what happened? Allegedly, she took bribe. She says that I got certain gifts, but there was no bribe. She shared her login credentials with a businessman, Mr. Hiranandani, and that businessman used the credentials of Mahua Moitra to post questions which could be asked to the ministers. And these questions were trying to embarrass Mr. Gautam Adani, who was a business competitor to Mr. Hiranandani, whatever the allegations are. So you are sharing these credentials with somebody who is not a member, and then you are taking bribe for asking questions inside the Parliament. This is the breach of privilege. But this breach of privilege was not inquired into by the Privileges Committee. It was looked into by the Ethics Committee. That is why there is a thin line, there is blurring of lines between the Privileges and the Ethics Committee. That is why the year was the 11th Lok Sabha. What it did, it recommended that these committees, Privileges Committee and the Ethics Committee, should be merged so that we can have only one committee known as Committee on Ethics and Privileges. Which of these statements are correct? While the Ethics Committee can only investigate misconduct by the parliamentary members, the Privileges Committee is vested with the authority to recommend penalizing non-members as well. This is correct. That is why some people say that this Mahua Moitra case was looked into by Ethics Committee because they did not want to penalize a businessman. They only wanted to touch the legislator. If Privileges Committee would have looked into this aspect, then the person who gave this bribe as well, he would also have to be penalized. The Committee on Privileges, yes, recommended in the 11th Lok Sabha that we should merge the two committees. The debate on the report of the Privileges Committee as well as Ethics Committee should not exceed half an hour duration. This statement is also correct. That is why C, 3 statements, that is the right answer. What do you mean by non-members? People like you and me, yes, we are non-members. Okay. Let's look at question number 6. Consider the following statements regarding the rules notified by the government regarding the Citizenship Amendment Act 2019. Statement number 1. An applicant needs to submit a certificate from an educational institution certifying that the applicant knows one of the languages mentioned in the 8th schedule of the Constitution. The Act creates the legal right for the 6 minority communities from the 3 countries to apply for Indian citizenship if they were religiously persecuted, even without travel documents like passport and visa. Which of the above statements is or are correct? Only one, only two, both, none. Let me know what is the right answer. And those of you who have attempted this answer, and if you are yet to like this session, don't leave without pressing the like button and subscribe to our channel if you haven't yet. Statement 1 is wrong. Go with the minority. Can a nominated member of Rajya Sabha be eligible to become a minister? Yes. C, simple, lock. You're wrong. B, only 2 is the right answer. Citizenship Amendment Act was passed in the year 2019, and this law or this amendment basically amended the Citizenship Act of 1955. According to this amendment, if you are from Pakistan, Afghanistan, and Bangladesh, and if you belong to 6 religious minorities of these 3 countries, Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs, and if you have entered India on or before What's the cutoff date? 31st December 2014. Then you are not deemed as illegal migrant. When you are not deemed as illegal migrant, which means then you are eligible for citizenship. Through what route are you eligible for citizenship? Naturalization. And for this class of people, the period of naturalization, which used to be 11 years, that means if I am somebody who is not from India, who is not a citizen of India, but I want to become the citizen of India, I had to stay 11 years in India if I wanted to get citizenship through naturalization. But for this class of people, the period of naturalization was reduced from 11 to 5 years. Now listen to me carefully. If I would have mentioned that illegal migrants from Pakistan, Afghanistan, Bangladesh who have entered India on or before December 31, 2014 are eligible for Indian citizenship, is that statement correct or incorrect? Priya says wrong. Wrong? Yes. Because illegal migrants under no circumstance are eligible for citizenship of India. But if you are from Pakistan, Afghanistan, Bangladesh, and if you belong to 6 religious minorities, and you come to India on or before 31st December 2014, you are not deemed as a legal migrant. You may be, but you're not deemed, which means you're eligible for citizenship through naturalization. And for you, the period has been slashed from 11 years to 5 years. Clear? But how to implement this law? For that we need rules. For example, how would we know that you are from Pakistan, Afghanistan, Bangladesh? How would we know that you are from Hindus, Sikhs, Christians, Buddhists, Jains, Parsis, Jains? How would we know that you have entered India on or before 31st December 2014? For that, rules are to be made. Now listen to me carefully. Rules say, when President has given her assent, that means if a law is passed today and the President has given an assent today, within 6 months, these rules should be made. That means if the law is passed today, it is assented to by the President today, then within 6 months of the assent given by the President, rules to implement this law needs to be made by the executive. If not, then what? Because the law was passed in 2019. It was assented to by the President in 2019 as well. But the rules were made in 2024. It took 5 long years. How is that possible? Sir, you're wrong. Then in that case, you have to seek extension from Parliamentary Committee on Subordinate Legislation. And do we have Parliamentary Committee on Subordinate Legislation in Lok Sabha as well as Rajya Sabha? Yes. It consists of 15 members, including chairman, in both Lok Sabha as well as Rajya Sabha, and all these members, they are nominated by the Speaker in Lok Sabha, by the chairperson of the Rajya Sabha in the Rajya Sabha. And multiple times, 8-9 times, extension was given by this Parliamentary Committee on Subordinate Legislation to the Ministry of Home Affairs, because MHA, Ministry of Home Affairs, is the nodal agency for all matters related to citizenship. And finally, in 2024, the CAA rules were made and Citizenship Amendment Act has now been implemented. But listen to me carefully. whenever a statement on CAA rules is or are asked in the examination, keep one thing in mind. If that statement is difficult in the sense, if the requirement mentioned in that statement is difficult, then you should consider that's an incorrect statement. Because the whole purpose of the government is to smooth or to simplify the process of citizenship. So the government will not do anything which will make it difficult for people to get citizenship through CAA. So any rule, if it is mentioned, any option which is mentioned, if it is difficult to obtain, difficult to achieve, then consider that statement is incorrect. Which means, how would the government know that you are from Pakistan, Afghanistan, Bangladesh? Rules say, give us any document which can say that you were born in Pakistan, Afghanistan, Bangladesh. Any document. Or any document which can say that your parents or their parents were born in Pakistan, Afghanistan, Bangladesh. Any document. And we will accept it that you are from Pakistan, Afghanistan, Bangladesh. How would we know that you belong to Hindus, Christians, Sikhs, Buddhists, Jains, Parsis? Give us any document, even if it is given by the priest. If the priest has given a document that, yes, I know this person is a Hindu, we will accept that document. How will we know that you have entered India on or before 31st December 2014? Give us any document. Any document can be, you may have an Aadhaar card, because Aadhaar is not a proof of citizenship. Aadhaar is the proof of identity. Any resident, usual resident, and who is a usual resident? Somebody who is residing in India for 6 months or more. That person is a usual resident. So even foreigners can get Aadhaar. Whether you have Aadhaar, whether you have PAN, whether you have driving license, any document which can say that you have entered on or before December 31, 2014. Maybe there was a census slip which was given to you when house listing was going on. Give us that slip which can convince us that you have entered on or before 31st December 2014. We will accept it. But now two things. If you are eligible for citizenship through naturalization, there are some other conditions that you have to meet. One such condition is that you should be well versed in any language mentioned in the 8th schedule of the Constitution. And there are 22 languages mentioned in the 8th schedule of the Constitution. Now previously, somebody who wants to acquire Indian citizenship through naturalization, he had to give a school certificate. School certificate which should have mentioned that this is the language which you are accustomed to, which you are familiar with, which you have passed with flying colors in your school, so that the government can be satisfied, the Home Ministry can be satisfied that you are well versed with an Indian language. Even this requirement has been made simple. Now you don't need a certificate from an educational institution certifying that I am knowledgeable about any language mentioned in the 8th schedule of the Constitution. Even a self-declaration is sufficient. I will give a declaration that I know Hindi. I will give a declaration that I know Tamil. I know Kannada. I know any language mentioned in the 8th schedule. We will accept it, no questions asked. Which means these rules are made simpler and simpler for these people to get citizenship. So that is why this statement is incorrect. The Act creates legal right. Now what's a legal right? A right which is provided by the law. This Act creates a legal right for 6 minority communities from 3 countries to apply for citizenship if they were religiously persecuted, even without travel documents like passport and visa. This statement is correct. Because you don't need passport, you don't need visa either. Which means we don't deem you to be an illegal migrant. But listen to me carefully. Some of you may have this confusion. Sir, this religious persecution, this is not mentioned in the law. But this is mentioned in the statement of objects and the reasons of the law. So when a law is being presented, the minister will also announce the reason, the statement of objects and the reasons why we are bringing this law. And all the government websites that you will see, whether the websites of foreign embassies, Indian embassies in foreign countries, or MHA, or the rules, they do mention religious persecution. That is why this religious persecution now becomes a correct statement. although the law does not refer to religious persecution. That is why B only 2, B is the right answer. Clear? Staying with citizenship, there is something called Section 6 capital A of Citizenship Act. Whether Section 6 capital A of the Citizenship Act is constitutional or not, the Supreme Court, Constitution bench of the Supreme Court was hearing this matter. And now all hearings have been concluded. We are waiting for the final verdict. We don't know when that verdict will come. But what is the Section 6 capital A of the Citizenship Act may be important for your examination. Can anybody tell me what is this section all about? Now you can't say Assam Accord. Mention specifically what? Again, Assam 1971 NRC. What is Section 6A of Citizenship Act? Krishna is right. Different cutoff date. What is the cutoff date? If we look at, listen to me carefully. If we look at Part 2 of the Constitution, it deals with citizenship. Normally, citizenship is not a matter which is dealt by the Constitution. This is a matter which is left to the political class, left to the legislature. You make a law, you define who can be the citizen, who cannot be the citizen, who is eligible, who is not eligible. But India is unique because the country was partitioned on the grounds of religion. And when the country was partitioned, there was massive migration of people from India to what became Pakistan, and migration of people from what became Pakistan to India. So we had to be absolutely sure that at the time of the commencement of the Constitution, who are the citizens of India? That is why we have articles such as Article 5, 6, 7, 8, 9, 10 of the Constitution. All those who migrated from India to what became Pakistan after 1st of March 1947, they are not the citizens of India. But all those people who came from Pakistan to India July 1948, they are the citizens of India. That means those who migrated from India to Pakistan, if you migrated after 1st March 1947, you are not the citizens of India. But if you came from Pakistan to India before 19 July 1948, you are the citizens of India. But those who migrated after 19 July 1948 from Pakistan to India, those who wanted to come back, they cannot become the citizens of India unless and until they take the permission. That means the government will decide out of all these people who are allowed to come back, who are allowed to become the citizens. Long story short, there is a cutoff date. Whoever has come to India before 19 July 1948, you are the citizens. If you have come to India after 19 July 1948, you have to register as a citizen. And it is for the government to decide whether we will accept your citizenship or not. But Assam had a different case. There was a problem, there was a concern that there is a massive illegal migration of non-Assamese, non-indigenous Assamese into Assam. And a massive movement was launched in 1979, which remained till 1985, known as the Assam Agitation, which was led by ASU, All Assam Students Union. Their principal objective was, we should identify these illegal migrants, arrest them and deport them back to the country of their origin. It was in 1985 that a historic Assam Accord was signed between the protesters, the government of India and the state government of Assam. And ultimately it was decided that whoever has entered before January 1st, 1966, you are the citizens. No questions asked. But if you have entered Assam between 1st Jan 1966 to 25th of March 1971, you are a citizen of India, but for 10 years, you will have no political rights. That means for 10 years, you cannot contest elections. For 10 years, you cannot vote. And listen to me carefully. After this 10-year period, you have to register as a voter. You have to register as a citizen. But whoever has entered Assam after 25th March 1971, you are an illegal migrant. You will be arrested. You will be deported back to the country of your origin. Which means for the rest of the country, the cutoff date is 19 July 1948. But for Assam, there is the cutoff date 25th March 1971. Can in a country we have two cutoff dates for citizenship? Because this cutoff date is provided by Section 6 capital A of the Indian Citizenship Act. And this was amended and provided for when the Citizenship Act was amended in 1985, which was because of the Assam Accord of 1985. Now the 5-judge constitution bench of the Supreme Court has to decide whether this different cutoff date is possible or not. And that is why to implement Assam Accord in Assam only, NRC was conducted. NRC was updated in 1951, was first prepared in 1951 after the commencement of the constitution, but it was updated only for Assam on the directions of the Supreme Court. And what is NRC? It contains details of only the citizens of India, not the foreigners. So NRC was updated only for Assam, and that too on the directions of the Supreme Court. Clear? Any questions? Okay, Priya Kumari is asking a very good question. Let's see what is the right answer to this question. Previously, or normally, the citizenship matters, whether you will be granted citizenship or not, that is dealt by the district authorities. For example, district collector in a district is the authority to decide on citizenship matters based on the law passed by the parliament, based on the rules issued by the executive. But because there are state governments which say we will not implement CAA, for example, Kerala, for example, Tamil Nadu, for example, West Bengal, that is why in these CAA rules, the government has done something which is to bypass these states. That is why all these applications of citizenship under CAA, all these applications will have to be furnished online, and instead of the district authorities, we will have an empowered committee which will be headed by Director of Census Operations. And we will have a district level committee which will be headed by District Informatics Officer. And whether it is this empowered committee or the district level committee will be constituted by the central government. So all the applications under CAA have to be dealt electronically, and that too by committees which are created, constituted by the central government, which means states have no role in these matters. And it is also justified in a sense. Citizenship is a union subject. It is under the exclusive control of the central government. Clear? Okay. Let's look at question number 7. Aadhaar is individual data whereas National Population Register contains family-wise data. No document is collected during the NPR exercise. NPR was first prepared in 2010. What is the right answer? You have 30 seconds. Let me know what is the right answer. Shojanya B, Fayaz B, Mr. Saini B. Kindly lock option B. Okay, Fayaz, if you're saying we have to lock option B, I will lock option C instead. Aadhaar, it is a unique 12-digit identification number. What makes it unique? You would know fingerprint, iris scan, biometric details are to be provided. That's what makes it unique. And we have a statutory organization known as Unique Identification Authority of India, which is responsible for Aadhaar. But Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. Aadhaar proves that X is X. Nothing more, nothing less. That is what Aadhaar does. Aadhaar is a proof of identity. NPR, which is conducted under the citizenship rules, because when the citizenship rules were enacted in 2003, because 2003 we saw another amendment to the Citizenship Act, then rules were made, and it talks about something related to NPR. And what is that NPR? It was first conducted in 2010. It was again updated in 2015. And then it was supposed to be conducted in 2020 as well. But then because of the COVID-19 pandemic, it was postponed. And when this NPR exercise was to be conducted in 2020, there was a lot of controversy because some people alleged that it is not NPR. It is basically NRC, but in disguise. How? We don't have to get into that. That is irrelevant, maybe relevant for mains, not here. But long story short, Aadhaar is only an individual data. It gives data about an individual, not the family. Mr. P. Chidambaram, when he was the Home Minister in 2010, he conceptualized this idea of let's have National Population Register because it will give us the family data. It will give us data about the migration of people. It will, migration in the sense, NPR contains details of those who are the usual residents of India. And who are these usual residents of India? Those who have resided in India for 6 months. And those who want to reside in India for a further period of 6 months. You are a usual resident of India. That means this usual resident can be a citizen, can be an alien as well, can be a foreigner as well. And this NPR will give us the details about the migration of the families from different parts of the country. And that is how the central government decided, Mr. Chidambaram decided, that we can make policies and programs. We can have social security schemes for such people. We can target people based on their migration and various other reasons. So NPR gives family-wise data. Aadhaar gives individual data. This statement is correct. No document is collected during NPR exercise. This statement is also correct. No document will be asked. And NPR was first prepared in 2010. This statement is also correct. So C, 3 statements. That is the right answer. But to delve further into it, listen to me carefully. we need to also understand census. Why? Because census also has been postponed. It was supposed to be conducted in 2021, but it has been postponed because of COVID-19 pandemic. Clear? Census comes under union list. That means who has the power to conduct census in India? Not the states, but the central government, because census is a union subject under 7th schedule of the Constitution under the distribution of powers. But sir, there was a caste census carried out in Bihar. There is another census carried out in some other states in India. That is not census, that is a survey. So there is a difference between census and survey. What was carried out in Bihar was a caste survey. Census is different, and the details of census, they remain secret. They cannot be shared with anybody. It's a confidential data. Census was for the first time conducted in India in 1882 when we were under the British colonial rule. But this was an asynchronous census, not conducted throughout the country at the same time. The first synchronous census, or should we say it was first conducted in 1872, but it was an asynchronous, non-synchronous census. But the first census was carried out in 1881. And since then, every decade, this census exercise has been carried out. 1931 becomes important, and I'll tell you briefly why. Then after the independence, 1951, consistently, every 10 years, this is a decadal exercise. Every 10 years, census exercise is carried out. Clear? But it was not carried out in 2021 because of the COVID-19 pandemic. In India, we have the Census Act of 1948, under which census is carried out. And the responsibility of carrying out the census is with the Registrar General and Census Commissioner of India. And this office is under Ministry of Home Affairs. If you look at countries such as United States or Japan, they have a statutory requirement that every 10 years or every 5 years, you have to carry out census. But in India, neither the Census Act of 1948 nor the census rules which were passed in 1990, these rules or this act does not talk about a specific date or the specific year or the specific time period within which the central government has to carry out the census exercise. That's an important statement, can be asked in the examination. But the census is carried out in 2 phases. Which are these 2 phases? Phase number 1 is house listing, also known as housing census. For example, all the housing installations will be identified. That's how policymakers will get to know how many kacha houses, pakka houses do we have, how do people live in India, and accordingly policies and programs can be made. And it is during this housing listing or housing census that NPR is carried out, National Population Register is carried out. That means NPR becomes part of the census exercise, but the first phase of the census. Then 6 to 8 months later, that means 6 to 8 months after the house listing or housing census, we have something called population enumeration. That means now the population will be counted, enumerated. And this is where questions will be asked. Questions such as, what is your age? What is your marital status? For women, the question will be asked related to their fertility. Questions will be asked related to mother tongue. Questions will be asked related to, let's say, what is the economic activity that you are pursuing. Questions related to your educational activity or educational status. Questions related to disability. Questions related to whether you are from SC or ST community. Questions related to religion. Which means, is caste data captured by census? Yes. Caste, SC and ST. Not other backward castes, not OBCs. The year was 1931. That's why I said this 1931 year is important. This was the last time when all the caste data was captured by the census. The next census, which was conducted in 1941, the then colonial government decided not to include the caste data. Why? Because it would have cost them a lot of money. Because at that time the Second World War was going on. That is why till 1931 we had all the caste breakup details. But after 1941 onwards, this caste data was not captured. What was captured was SC/ST status, not the status of other castes. And that is why there are political parties such as the Congress and others who are claiming that we should have a caste census. Which means we know SCs and STs, but we want to know the status of other backward castes as well, other backward classes as well. That is what they mean by the caste census. Clear? Done? There was something called socio-economic caste census, which was conducted in 2011. But the details regarding the caste, these details have not been made public. These reports have not been made public. Although there was a Ministry of Urban Affairs, there was a Ministry of Rural Affairs as well. They looked at this socio-economic caste census data without the caste breakup. That details, those details we do not know. So what is the answer to question number 7? C. 3 statements are correct. C is the right answer. Okay. Question number 8. The Office of the Registrar General and Census Commissioner is responsible for which of the following activities? Housing and population census, civil registration system, sample registration system, national population register, mother tongue survey. Which of these statements are correct? Select the correct code from below. Tell me what is the right answer. Majority of the students are saying it's an easy question. Your boss saying option C, lock it, sir. Sorry, my boss, I can't. Okay. D, all the 5 is the right answer. Housing and population census, housing, house listing, and then population enumeration. That is the job of the Registrar General and the Census Commissioner. We have discussed, this is correct. Civil registration system, this is also the job of this body, and they do it in association with the state governments. And this is how they get to know about, they are responsible for the registration of births and deaths. Then there is something called sample registration system, which is half yearly exercise And through this sample registration system, we get to know details about a lot of indicators. For example, infant mortality rate, maternal mortality rate, what is the birth rate, what is the death rate. The National Population Register, which I have told you is conducted in association with Housing Census. That is also the job of this body, Registrar General and Census Commissioner. Mother Tongue Survey. And do you know Mother Tongue Survey? Its report was released in 2022. What is this Mother Tongue Survey? For example, here, when you have to answer these questions, when census is carried out, you also tell about your mother tongue. What is your mother tongue? Now, all these mother tongues, or the data which has been captured in the last 2 decades in the 2 censuses, all those are looked into, identified, and the analysis of these mother tongues is conducted. The features of this mother tongue are ascertained. And that is the job of this Mother Tongue Survey, and which the report of which was released in 2022, which makes it a potential question for your upcoming prelims examination. Clear? Okay. Let's look at another question. Question number 9. The Supreme Court in Rupa Ashok Hurra enumerated all the grounds on which a curative petition could be entertained. The last curative petition heard by the Supreme Court was the Union government's plea to increase the compensation given to the victims of the 1984 Bhopal gas tragedy. The curative petition shall be filed within 30 days from the date of judgment or order passed in the review petition. The curative petition shall be first circulated to a bench of 3 senior-most judges and the judges who pass the judgment which is being complained of, if available. Which of these statements is or are correct? You have 1 minute. This is a very important question. Why? Because something happened recently in April 2024 and something happened last year as well related to curative petition. Think about it. You can make an intelligent guess right now. Fayaz, whenever you say lock it, I am constrained not to lock it. Make an intelligent guess. Okay. Question number 9. What is the right answer? Only one statement is correct. A is the right answer. Let me explain. Supreme Court has the power to review its own judgment. So, for example, there is a case which was heard by the trial court, then went up to the High Court, then went up to the Supreme Court. Supreme Court gave a verdict. But if the verdict is given today, within 30 days, you can approach the Supreme Court again and file a petition requesting the Supreme Court, could you please review your judgment? And this petition is what we call the review petition. And review petition is accepted by the court on 2 grounds. If an error has been pointed out, if there is an error in your judgment and the petitioner has pointed out that error, could you please clear that error? Or if new facts have emerged. I will not go too deep into this, but you will have an idea. If a judgment is given by the Supreme Court has the power to review its own judgment, and that is mentioned in the Constitution. But this review petition can be filed within 30 days of the previous judgment, and it can be accepted by the court if the petitioner is pointing out an error in the judgment, or if new facts have been emerged in this case which will give you a favorable verdict. In that case, review petition is accepted. That's it. This was all that was there mentioned. The year was 2002. It was primarily a matrimonial dispute between Rupa Ashok Hurra versus Ashok Hurra, and this is what we call Hurra versus Hurra judgment. The Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. So there has to come a time where the judgment will become final. Res judicata, something that we discussed yesterday. After that, you cannot further file a case. But we cannot be indulging in miscarriage of justice. That is why once the review petition is rejected, you can file another petition, and that another petition is what we call as the curative petition. But when can you file this curative petition? That's question number one. So you can file this curative petition within a reasonable time frame. Review petition is filed within 30 days of the judgment. Curative petition is filed within a reasonable period. And what is that reasonable period? We don't know. And it was after decades, after the dismissal of the review petition, that the court accepted the curative petition of the union government, because the union government wanted to enhance the compensation which should have been awarded to those who suffered because of the Bhopal gas tragedy in the Union Carbide case of 1984. But this review petition can be filed this curative petition can be filed within a reasonable time period. And what is that reasonable time period? We don't know. That is not mentioned. That's number one. Number two, on what grounds can you file this curative petition? In Hurra versus Hurra, the Supreme Court did not elaborate that on these strict grounds you can file or we can accept this curative petition. But largely what we have seen, that Supreme Court accepts curative petition when it wants to cure the miscarriage of justice, where principles of natural justice have been violated, where the judgment has adversely affected the petitioner, for example, death sentence cases. I am awarded death sentence by the Supreme Court. I filed a review petition. This review petition was rejected. I'll file a curative petition. Why? Because in death sentence case, I am adversely affected. If principles of natural justice have been violated, for example, the judge who heard this case, he did not explain, he did not reveal that there is a conflict of interest. He is very close to the party, to the opposite party, where my review petition was dismissed without hearing me. So the judgment was given ex parte, without hearing the other side, without hearing the other party, where the judges were biased against me. If all these things are mentioned in that curative petition, same thing should have been mentioned in the review petition as well. So whatever you are claiming today, you should have claimed that in the review petition as well. That got rejected. File another review petition known as the curative petition. But now this time it will be sent to 3 senior most judges of the Supreme Court, as well as those judges who gave this verdict. And then they will decide whether we need to hear this case again or not. The most recent case is that of Delhi Metro Rail Corporation versus a company of Mr. Anil Ambani. Many years ago, if you would know, the airport line of the Delhi Metro was to be operated by Anil Ambani's company, but then they withdrew. It went to arbitration. Arbitration gave the verdict in favor of Anil Ambani. So Delhi Metro Rail Corporation had to pay 8,000 crore to Anil Ambani's company. Then the matter went to the High Court. Then the matter went to the Supreme Court. Supreme Court upheld the award of the arbiter. Then a review petition was filed, and review petition was also rejected. So Anil Ambani was the winner. But then curative petition was filed. And because of this curative petition, it is rare for curative petition to succeed. And this curative petition was accepted by the court. And what the court did, it said justice was miscarried. There was a miscarriage of justice in this case. And now this Delhi Metro Rail Corporation need not pay 8,000 crores to Anil Ambani's company. So that was the most recent case. Prior to that, the Union Carbide case. So let's look at these statements. The Supreme Court in Rupa Ashok Hurra enumerated all the grounds on which a curative petition could be entertained? No. It did not reveal all the grounds on which a curative petition can be entertained. The last curative petition heard by the Supreme Court was the Union government's plea to increase the compensation given to the victims of the 1984 Bhopal gas tragedy. This is incorrect because the last one was Delhi Metro Rail Corporation in April 2024 versus Anil Ambani. The curative petition shall be filed within 30 days from the date of judgment or order passed in the review petition. Incorrect. Why? Not within 30 days, but within a reasonable time period. The curative petition shall be first circulated to a bench of the 3 senior most judges and the judges who pass that judgment which you are complaining of, if these judges are available. This is correct. So only one statement is the right answer. This power is with the Supreme Court. Why Sri Lankan Tamils are not given citizenship? Because they are also persecuted. They are not persecuted because of their religion. They are persecuted because of their ethnicity. So there is a difference between persecution based on ethnic grounds and persecution based on religious grounds. And at the end of the day, it's the policy of the government. And policy making is the job of the executive. High Court has the power to review its own judgment, yes. So that is it today. We are running, the time is up. It has crossed 9 p.m. Whatever questions you have, please let me know. I'll try my best to address them. But remaining questions which we had to cover today, we will cover them tomorrow. Is it contempt of court? What is contempt of court? Rohingyas aren't included. That's again the policy of the government, that the court will have to decide whether that was right or wrong. High courts can review their previous judgments. That's what I've said. High courts can. But when I'm talking about curative petition, that means after the review petition, filing another petition called curative petition, that's with the Supreme Court. Why only 1 rupee fine for Mr. Bhushan? Because the then Attorney General, Mr. K.K. Venugopal, persuaded the court that yes, Mr. Bhushan has committed contempt, but he has also done a lot of good things. He is filing a lot of cases before the court for the marginalized, weaker sections of the society without charging a penny from them. So he has done a lot of good work, social work as well. That is why only 1 rupee fine should be imposed. Curative petition can be filed only after the review petition. Curative petition is not mentioned in the Constitution. Curative petition can be taken as contempt of court. No, you can't take it as contempt of court. Why? Because you are alleging bias on part of the judiciary. That's your ground. So you are approaching the court, giving details that it appears that there is a bias against me. Principles of natural justice have been violated. So that is not contempt. What is the minimum fine for contempt of court? 1 rupee. Difference between NPR and census, National Population Register, you can say, is one aspect of census which is conducted during first phase of the census, which is house listing, housing census. Sir, if the question is asked that the post of Deputy Speaker is mandatory in Lok Sabha, if it is mentioned according to the Constitution, the post of the Deputy Speaker is mandatory, you say yes. Review petition be heard only by the bench which has given the award? Yes. Okay, that is it for today. Thank you so much for staying with me. I'll see you tomorrow again, same time, 7:30 to 9 p.m. and we'll discuss lots and lots of MCQs and important concepts related to Indian polity relevant for the upcoming prelims examination. And if you have benefited from the session, do let me know in the comment section, and do not forget to press the like button, and see you tomorrow at 7:30. Till then, have a great time. All the best. Bye-bye. Good night.